there, my name is Eliza Kelly and I will be doing this week's tutorial on Native Title and Wik. Before we begin, I've just got a quote up on the screen which I think is quite pertinent to this topic. The very ink with which all history is written is merely fluid prejudice. The very ink with which all history is written is merely fluid prejudice. Now, this quote from Mark Twain hits what is really only the surface of an ongoing battle in broader history, but also in regards to Indigenous Australians and the conflict that has happened over the last 200 years from European settlement. And I think it's important for us to remember before we even broach this topic that history has for such a long time been written, conveyed with prejudice, with one side of the story, with the superior side of the story. The more powerful society has dominated that field. And so for a long time, we weren't able to hear from minority groups. And I think it's a really important topic that we're addressing today as we look at Native Title and Wik and what that looks like as Indigenous Australians started to gain some of the rights and be able to retell and rewrite history in perhaps a more pertinent and more equitable manner. So the first thing we should always discuss and broach is an understanding of terra nullius when looking at Indigenous land rights. Now, terra nullius is from the Latin. It is a physical translation to nobody's land. Often in Australian history, we regard it as land belonging to no one. Now, a principle under the European settlement was that when Captain Cook arrived, he declared Australia terra nullius, as land belonging to no one, because it did not have an establishment of society or culture or cultivation of the land that under European terms determined that it was owned by a certain group. Now, this really does highlight in essence the ignorance of what white superiority and singularity was like during the colonial era of the 20th century and back to those roots of the 18th century. It's really highlighted well in this quote from Auntie Beryl Timbury Bella. She says, "They were so ignorant, they thought there was only one race on the earth, and that was the white race. So when Captain Cook first came, when Lieutenant James Cook first set foot on Wongal land over at Kundal, which is now called Kurnell, he said, 'Oh, let's put a flag up somewhere, because these people are illiterate. They've got no fences.' They didn't understand that we didn't need fences, that we stayed here for 6 to 8 weeks, then moved somewhere else where there was plenty of tucker and bush medicine, and we kept moving and then come back in 12 months' time when the food was all refreshed." Now, this highlights a particular dilemma that has surfaced in more recent histories regarding Australian settlement. So terra nullius did declare in its European sense that the land did not belong to anyone. However, the Indigenous Australians did not see it this way. Aboriginal and Torres Strait Islander people have been here for thousands of years. And so for them, the land is not to belong to anyone. And this is the dilemma that arises and we'll see to continue to arise throughout the concept of native title rights, is that the land does not necessarily follow a sense of ownership, but rather, as we will begin to see, the Indigenous Australians saw themselves as custodians of the land. So what was the importance of the land? If we look at a cultural and spiritual perspective, the dreaming, which was the Aboriginal spiritual belief system, the land and identity are all interconnected and interrelated. I love this concept that we begin to see the beauty of the Aboriginal spiritual beliefs, that there was no difference, there was no ownership, there was no separation, but part of this wholesome belief system that the dreaming and the land and their identity was all interconnected. They gained a sense of worth and sense of purpose from looking after and cultivating the land, and they gained their identity and their ancestry through it as well. So we know the land is of extreme significance. It's a place where they're practicing ancestral customs and laws. It's a place of their heritage and it's a place where they pass down their oral histories as well. So like I've said, Aboriginal and Torres Strait Island peoples are custodians of the land. They don't see the land as something that should be owned or belonging to anyone. So the problem was, Europeans did settle in Australia. They followed a track of terra nullius and assumed that the land was there for their own use and for their own establishment of a white society. So what were the consequences of this? We know throughout Australian history the various policies that were put into place to try and manage, at times cooperate naively and ignorantly, not actually taking into consideration the rights and the wishes of Aboriginal and Torres Strait Islanders, that it didn't work smoothly and that we did hurt and do wrong by the Aboriginal and Torres Strait Islander peoples. So what does this look like in the present Australian legal climate? We get to the 1960s and we start to see a land rights movement start to develop for Aboriginal and Torres Strait Islanders. However, it's not until around the 1990s that we begin to see formalisation of this process. So I have got a definition here. The land rights movement is a religious and political movement to secure the rights of Aboriginal people to their land and ensure their religious, spiritual and cultural integrity is preserved. And this is all, again, inherently connected to the dreaming. However, we look at native title and we move into the 1990s, and this is where we have our first big formal legal native title claim under Mabo in 1992. And it's not our first big one, but our first big successful one. And so in 1992, Eddie Mabo, as a part of the Murray Islands, claims that his people had a right to that land that the Australians had taken away from them. Now this was the first successful Indigenous native title claim, and it incurred a lot of understanding and call for law reform as to what native title rights looked like, how they could be established and what they were organised under. And so as a result, we had the Native Title Act of 1993. Now this act outlined a number of main points. Firstly, it was there to provide recognition and protection of native title, that it was an actual right, that there was a recognition and insistence that this was a thing. It also was there to establish any future dealings with native title in the legal system. So we do know we have common law, the case-built law that would have stemmed from Mabo. They felt as though statute law, so our formal legislation, also needed to provide a platform for these claims. The NTA had provided a recognition that Indigenous Australians did have traditional interests and investments in the land. However, it also immediately put restrictions on this and said that a continuation of these interests must be demonstrated for any valid native title claim to be made. This meant that they had to demonstrate a connectedness to the land that was uninterrupted throughout Australian history, and that they had continued to observe their customs and traditions and laws on that land as well. This is extremely difficult considering the past 100 years of Australian history and what it looks like that Aboriginals and Torres Strait Islander peoples were forcibly removed from their lands. So we understand that obviously there's going to be groups that unfortunately just had that disconnection. And so basically the legislation is saying for them, there is no room for a native title claim to be successful. So what does this look like? We're recognising that we've got a naive period of peace perhaps, that we're understanding that yes, it's wonderful that native title rights are being recognised, but how does this play out practically? Murray Islands is off the coast of Australia, so what does it look like for the Australian mainland? Does native title exist on the Australian mainland? Had it been extinguished by legislation or government establishments or government buildings? Were there separate places that native title could exist? What were the implications for pastoral leases, for tenants, for mining leases, for infrastructure that had been built? Was native title going to outdo these existing land rights? What did this look like? And this is what arose, fortunately, in the Wik case. So Wik Peoples v the State of Queensland and Oars in 1996. Native title had had so many disruptions and contradictions within its legal boundaries. Wik gave a decision that started to extend and to clarify in a much needed way what native title really looked like for Australian people. So the Wik case determined the following: that there was a right to negotiate native title. So as we'd said, what happens when pastoral leases or mining leases or government establishes clash with a native title claim? There is, at first and foremost, a right to negotiate this. So people who have interest and investment in claiming native title rights, they do have that right to negotiate. What comes after that? Pastoral leases were declared that they could coexist with native title rights. However, at the same time, native title rights were the rights that would be yielded or be sacrificed if a conflict did arise, and pastoral leases, mining leases, government establishers would take priority. Another point which is important to put in there perhaps is that any government establishers or privately owned land that had already been set and tenured was not going to have any successful native title claims put against it. So who was affected by this? Obviously pastoral leases, farmers, caretakers, miners, establishment owners are all going to be affected by this updated legislation. Obviously people that have native title claims against such land tenures are going to have to somehow negotiate or work together to ensure that they don't have to yield and create conflict so that their rights are being put to the side. But obviously the big stakeholders, as always, are going to be politicians and our big businessmen. And that's what we really began to see come through when we look at the possibility of law reform following Wik, because there was a necessary and big push for native title law reform, as you would expect. What resulted was Howard's 10-point plan. And I've put the 10 points here up on the screen. So what did this mean? This resulted in the Native Title Act amendment of 1998, or as it has been phrased, a confirmation of past extinguishment of native title. And this is a funny play on words from the Sydney Morning Herald in their article, 10-point plan that undid the good done on native title. They extended in their article to say, but by purporting to confirm extinguishment by inconsistent grants, the Commonwealth is purposely preempting the development of the common law, not allowing sufficient time to integrate the belated recognition of native title into Australia's land management system. So basically they're saying that because they've extinguished the rights of native title in so many areas that we've already mentioned, there's no room for the common law, as our legal system has been built on, to make the foundations for land rights. It's too late. Australia's land management system has been set up. It's been existing for so long that native title claims are so late coming to the party that there's no space for the common law to make any radical or groundbreaking decisions. And we can see that. So that's the article there. I've put a link into the PowerPoint that'll also be on the handout. We can see that, and we'll see that in a minute when we look at some of the ongoing complications of it. But first, the positives. So obviously there's a large movement towards reconciliation in regards to native title and a number of small wins. First and foremost, the recognition that native title does exist, that Aboriginal and Torres Strait Islander peoples were the traditional owners of the land and they have rights to perform and to continue their customs and laws on the land. There's again a recognition of past wrongs and ignorant policy. We understand that from the significant apologies over time, Kevin Rudd's sorry apology, but also a number of other politicians that have recognised the injustice served against Indigenous peoples. Now this is a positive movement towards reconciliation, that again in the matter of the land rights movement we did wrong. An important act that is continually being used in public ceremonies was formalised in Parliament in 2008 as our Welcome to Country and acknowledgement of the traditional landowners. And also law reform in response to landmark cases. So even though perhaps pessimistically we can say that it's too late for any significant legal changes, law reform has taken place in Mabo and Wik. And they have pushed for at least the recognition of rights and the movement towards some sharing and compromise in regards to the land rights movement. But what are the continuing complications? There are still 589 active native title applications from over 1,000 applications, and only 30 successful native title claims out of 40 determinations, 30. Most agreed through consent and not adjudicated via litigation, which was one of those points of the 10-point plan. Another further complication is to understand that from this, and a reason why such a low success rate, is the cultural difference that we talked about at the beginning. The difference between ownership and custodianship is always going to create legal complications. The Aboriginal and in Torres Strait Islander people believe that they're custodians and that no one should own the land. However, under European law, someone does own the land. Someone has exclusive rights at most of the time to the land. And while these rights can be shared, there's always going to be one group who has a demanding right over the other. The case of Yorta Yorta in 2002, the Aboriginal community of Yorta Yorta claimed for native title in Victoria. However, after even appealing all the way to the High Court, they were denied, and it was said that it was just too late for them to be granted native title. The quote was that the tide of history had washed away their rights for native title, which I just think is an appalling thing to consider. Fortunately, in 2004, the Victorian government did come to a cooperative agreement with the Yorta Yorta community that has allowed them to use the land. Income controversy obviously is playing out on the fact that the economy drive behind some of this legislation that's all embedded in the politics is what is still making native title such an unsuccessful claim for Indigenous communities, because they're consistently up against government establishments, mining businesses, pastoral leases, farming tenants, all things that are going to be given priority because of their drive in the overall Australian economy. And within that, we're looking through again the priority stakeholders and who they are and how they continue to dominate that arena. So what does this mean for us as teachers? How does this affect our practice? And I really think there are two things that we really just need to take away from the land rights movement. And that is to recognise the significance of the land to Aboriginal and Torres Strait Islander cultures. That it is inherently connected to their ancestry, their spirituality, their culture, and that we need to recognise the significance in this and not be arrogant or ignorant in our teaching of this matter, and to make sure that we're always being respectful and aware of this relationship with the land and the dreaming. And second, that we should be respecting cultural and spiritual differences in the curriculum. Now, while the curriculum continues to move to a place that is recognising and teaching about Aboriginal and Torres Strait Islander peoples, it is still a place of controversy. It is still coming from perspectives that aren't always inherently Indigenous. And it's coming from a perspective that's still trying to fit into the schema and the paradigm of Western education and society. If you have any questions, please feel free to post them in the forum. Otherwise, please see attached the handout. I hope it's of help.